So, very good evening, all the participants. Today, I think we can start with the section 160 onwards. I had opened the file. Just a minute. Just give me 1 minute. Okay. So, section 160. Okay. So, I hope my screen is visible. Is it visible?
Yes,
Okay. So, section 160. Uh, Trisha ji, are you there?
यस सर।
ओके ओके। ठीक है गला या कुछ किसी और काजल जी को बोलूं पढ़ने के लिए?
सर मैं पढ़ मतलब ठीक है, मेरा थोड़ा बेटर है।
ओके ओके ओके। आप पढ़ लो काजल जी, इफ यू आर इफ कंफर्टेबल।
yes, sir,
काजल
yes,
यस
yes,
प्लीज।
sir.
सेक्शन
Okay.
160
हाँ,
and I'll explain wherever it is required. So
yes, sir.
section 160, yes. But
Yes.
first of all, before you start, please tell me what is this section 160 and what is the purpose behind this section 160? Any idea?
Yes, sir. When the liability is more than the asset, then
Right,
the bankruptcy trustee decides to disown that property. That is onerous property,
right.
basically.
So whether this property is part of the bankruptcy estate, if they ask
Yes,
you a question, whether this onerous property forms part of the bankruptcy estate,
it forms, but it has to be disclaimed by the permission of the adjudicating authority.
right, very correct. So, uh, and which type of property is not part of bankruptcy estate? There are certain properties which are not part of the bankruptcy estate. Can you give an example?
थर्ड पार्टी सर, प्रॉपर्टी
Hmm?
लाइन विथ थर्ड पार्टी।
सर प्रोविडेंट फंड यूज।
Right, very correct. So basically, excluded assets. Excluded assets, and then apart from excluded assets, as rightly pointed out by Trisha ji, PF, properties belonging to third parties, etc., etc. Yes. So with this background, I hope now things are clear. So section 160, please read section 160, Kajal ji.
Okay, sir.
Hmm.
Onerous property or bankrupt. The
Hmm.
bankruptcy trustee may, by giving notice to the bankrupt or any person interested in the onerous property, disclaim any onerous property which forms a part of the estate of the bankrupt.
So
That,
now, how you will find the persons interested in the owner's property? So what are the points on which you can identify whether this person is interested in the owner's property? Whether it is defined somewhere? They say if a person is interested. So now, whether it is defined somewhere?
sir, interested means if the person is engaged with that property in somehow.
सर
Right.
So he,
सेक्शन सेक्शन 163 में चैलेंज अगेंस्ट डिस्क्लेम प्रॉपर्टी है।
Hmm.
और उसमें दिया हुआ है कि एप्लीकेशन चैलेंजिंग डिस्क्लेमर मे बी मेड बाय फॉलोइंग पर्सन अंडर दिस सेक्शन टू एजुडिकेटिंग अथॉरिटी: any person who claim interest in the property, any person who is under liability in respect of disclaimed property.
Hmm.
A disclaimed property is dwelling house, any person who on that date of application for bankruptcy was in occupation or entitled to occupy the dwelling
Ah.
house.
So basically, these are all the types of, very good, these are all the types of persons who may be interested in the owner's property. Yes, please.
The bankruptcy trustee may give the notice under subsection 1 notwithstanding that he has taken possession of the onerous property, endeavored to sell it, or has exercised rights of ownership in relation to it.
Hmm.
A notice of disclaimer under subsection 1 shall determine, as from the date of such notice, the rights, interests, and liabilities of the bankrupt in respect of the onerous property disclaimed.
Hmm.
Discharge the bankruptcy trustee from all personal liability in respect of the onerous property as from the date of appointment of the bankruptcy trustee.
Hmm. So there may be certain liabilities also which may be attached to this one onerous property. So he will be discharged from this uh, personal liability also, because now he is holding all these properties in a fiduciary capacity on behalf of the bankrupt. So even bankruptcy trustee will be discharged from all personal liability in respect of the owner's property as from the date of the appointment of the bankruptcy trustee. Yes.
A notice of disclaimer under subsection 1 shall not be given in respect of the property which has been claimed for the estate of the bankrupt under section 155 without the permission of the committee of creditors.
So now we have to refer to section 155 also. Now it says a notice of disclaimer shall not be given in respect of the property which has been claimed for the estate of the bankrupt under section 155. So now what is 155 and what 155 says? 155 says 155 talks of the estate of the bankrupt.
Bank.
So it says what is included in the estate of the bankrupt, right? And what is not included. So what is not included is excluded assets, property held by the bankrupt on trust, all sums due to workmen or employee, PF, pension fund, gratuity fund, and such assets as may be notified by the central government in consultation with any financial sector regulator. Why this reference to section 155? Any idea? Why they are referring to this section? In 160, why they are referring to section 155? Is it correct or some other section should have been given?
No, sir, it's correct because it's defining that what should be included and excluded from the estate of the bankrupt.
Mhm. But does section 155 refer to the permission of the COC anywhere?
Sir, COC permission is not required because
Okay.
it's without the permission of the COC.
So this says basically कि without you have to take prior permission of COC also, right? So before giving this notice, now the meaning of section 160 subsection 4 is that before giving this notice of disclaimer, you have to take the permission of the COC, right? This is the meaning. Next.
A notice
Section.
of
Ha. Hmm.
a notice of a notice of disclaimer under subsection 1 shall not affect the rights or liabilities of any other person, and any person who sustains a loss or damage in consequence of the operation of a disclaimer under this section shall be deemed to be a creditor of the bankrupt to the extent of the loss or damage.
Hmm. So it says there could be some other person also. More than one person could be interested in a particular property. So it says notice of disclaimer. If you are giving a notice of disclaimer, who is giving the notice of disclaimer? The
Bankruptcy.
bankruptcy trustee with the permission of the committee of creditors. Right? So he
Yes,
will
sir.
give this notice with the permission of the committee of creditors. But there may be some other person also, and this notice of disclaimer shall not affect the rights or liabilities of any other person. And any person who sustains a loss or damage in consequence of the operation of a disclaimer under this section shall be deemed to be a creditor of the bankrupt to the extent of the loss or damage. Now, suppose there is a loss or damage in consequence of the operation of a disclaimer. Can you give some example for this? Section 160, subsection 5.
Yes, sir. If there is a cinema hall
Hmm.
and if caterer is there and
Hmm.
if he has attached some attachments are there for the he has opened a shop and he has made some attachments.
Hmm.
If the that property is disclaimed, then he will
Hmm.
have so he can claim that amount of attachments that
Hmm.
uh,
Hmm.
from the adjudicating authority that I will suffer such a loss and that will be claimed.
Hmm. Hmm. Right. Now, the term owner's property also has been defined. So, what it means? Explanation. Please read explanation.
Yes, sir. For the purposes of this section, the term onerous property means any unprofitable contract
Hmm.
and any other property comprised in the estate of the bankrupt, which is unsaleable or not readily saleable or is such that it may give rise to a claim.
Hmm. Yes. Yes. Next.
No notice of disclaimer under Section 160 shall be necessary if
Hmm.
a person interested in the onerous property has applied in writing to the bankruptcy trustee or his predecessor, requiring him to
Hmm. Ah.
requiring him to decide whether the onerous property should be disclaimed or not, and a
Hmm.
decision clause A has not been taken by the bankruptcy trustee within 7 days of receipt of the notice.
Hmm.
Any on property which cannot be disclaimed under subsection 1 shall be deemed to be part of the estate of the bankrupt.
Hmm.
Explain for the purposes of this section, an onerous property is said to be disclaimed where notice in relation to that property has been given by the bankruptcy trustee under section 160.
Hmm. Right. Now 162. So there is a difference between 160 and 162. 160 is talking of property and 162 is talking of leaseholds. So I normally give the example of leasehold rights. Leasehold rights are not basically tangible property, but suppose there is a cinema hall and the personal guarantor has taken exhibition rights in respect of that cinema hall on a lease basis for a period of 5 years, right? Similarly, you've got leasehold rights to for extraction of mines for a specific period. So the payment which you make that will be reflected in the balance sheet on asset side. And suppose the deposits from that mine have exhausted, right? Or the leasehold rights do not have any value because that cinema hall is no more functional. So in that case, you may like to disclaim that leasehold right. So this is the section which relates to disclaimer of leaseholds. Yes, please.
The bankruptcy trustee shall not be entitled to disclaim any leasehold interest unless a notice of disclaimer has been served on every interested person and no application objecting to the disclaimer by the interested person has been filed with respect to the leasehold interest within 14 days of the date on which notice was served, and where the application objecting to the disclaimer has been filed by the interested person, the adjudicating authority has directed under Section 163 that the disclaimer shall take effect.
Hmm. Now, why they are separately mentioning about leaseholds? What could be the reason? Because property includes leasehold rights also. So why they have given separate section for this? Any reason? Any reason you can see for this? So why they are discussing leaseholds separately?
So leasehold rights are for a certain period.
सर ऑब्जेक्शन इसमें डिस्कस कर रहे हैं ना कि ही इज एंटाइटल्ड टू गिव ऑब्जेक्शन टू एडजुडिकेटिंग अथॉरिटी.
Hmm. No, no, no. Do you mean to say that in section 160 or 161 he cannot object?
बट सर यहाँ तो एकदम एक्सप्लिसिटली लिखा हुआ है ना कि ऑब्जेक्शन अगर वो नहीं देता है तभी वो माना जाएगा लीज होल्ड का डिस्क्लेमर। यहाँ तो एक्सप्लिसिटली दिया हुआ है
तो
वहाँ।
161 में भी दिया हुआ है एक्सप्लिसिटली।
बट
161
सर
में अब क्या फर्क?
ऑब्जेक्शन की तो बात कहीं भी नहीं हो रही है सर।
क्यों नहीं हो रही? 161 में क्यों नहीं हो रही? नो नोटिस ऑफ डिस्क्लेमर इज नेसेसरी इफ ए पर्सन इंटरेस्टेड इन द ओनर्स प्रॉपर्टी हैज अप्लाइड इन राइटिंग। तो दे तो दिया अप्लाइड इन राइटिंग, देने दिया। 161 में भी है, 161 में क्यों नहीं है? चलिए नेक्स्ट 162 पढ़िए पढ़िए प्लीज।
Where the adjudicating authority gives a direction under clause B of subsection 1, it may also make order with respect to fixtures, improvements by tenant and other matters arising out of the lease as it may think fit.
Yes, 163.
Challenge against disclaimed property. An application challenging the disclaimer may be made by the following persons under this section to the adjudicating authority: any person who claims an interest in the disclaimed property, or any person who is under any liability in respect of the disclaimed property, or where the disclaimed property is a dwelling house, any person who on the date of application for bankruptcy was in occupation of or entitled to occupy that dwelling house. The adjudicating authority may, on an application under subsection 1, make an order for the vesting of the disclaimed property in or for its delivery to any of the persons mentioned in subsection 1.
So they may say that, okay, let that person have that property. Because to the what is the concept of onerous property? The concept of onerous property is it doesn't have any value, or the liability is more than the accrual from that property. So they say if a person is interested, or if a person is under liability, let him have this property, right? So it will say, the adjudicating authority will say that this property, this disclaimed property will vest in that person, you know, who claims an interest. Like we give the example of an agriculturalist who has been given the rights of cultivation. That property may no longer be saleable. The bankruptcy trustee may not be interested. He might have given an advertisement for sale of that agricultural land, but nobody might have come up. So in that case, the adjudicating authority may say that let that agriculturist have that property. This is the meaning. Yes.
The adjudicating authority shall not make an order in favor of a person who has made an application in clause B of subsection 1, except where it appears to the adjudicating authority that it would be just to do so for the purpose of compensating the person.
So the idea is the vesting shall be done in favor of such a person for the purpose of compensation, right?
The effect of an order under this section shall be taken into account while assessing loss or damage sustained by any person in consequence of the disclaimer under subsection 5 of section 160. An order subsection 2 vesting property in any person need not be completed by any consequence, assignment or transfer.
So no explicit consequence, assignment or transfer is needed. Simply the order of the adjudicating authority is sufficient. Yes, 164.
Undervalued transactions. The bankruptcy trustee may apply to the adjudicating authority for an order under this section in respect of an undervalued transaction between a bankrupt and any person. The undervalued transaction referred to in subsection 1 should have been entered into during the period of 2 years ending on the filing of the application for bankruptcy and caused bankruptcy process to be triggered.
So these are the two conditions. Number one, the look back period is there, and 2 years here is ending on the filing of the application for bankruptcy. But in case of PUFE transactions, like section 45, section 45, what is the look back period?
2 years from the date of commencement of CIP.
So So that is in here, it is 46. 46 says within the period of 1 year preceding the insolvency commencement date.
And 2 years from the
Ha,
uh,
2 years preceding the insolvency. But here it is not the bankruptcy commencement date, it is the ending on the filing of the application for bankruptcy. So that
so
is the
here,
difference.
so it
So,
is the initiation date.
initiation date, right. And moreover, it caused the bankruptcy process to be triggered. So had this transaction not taken place, the bankruptcy process would not have triggered. So these two are the points.
A transaction between a bankrupt and his associate entered into during the period of 2 years preceding the date, date of making the application for bankruptcy shall be deemed to be an undervalued transaction under this section.
Hmm. So what it says? What is the meaning? The meaning is if a transaction is entered into between a bankrupt and his associate. So in that case, there is a deeming fiction, right? So there is a deeming fiction that it is an undervalued transaction. So even if they say it was at market value, still it will be deemed to be an undervalued transaction.
On the application of the bankruptcy trustee under subsection 1, the adjudicating authority may pass an order declaring an undervalued transaction void. Pass an order requiring any property transferred as a part of an undervalued transaction to be vested with the bankruptcy trustee as a part of the estate of the bankrupt, and pass any other order it thinks fit for restoring the position to what it would have been if the bankrupt had not entered into the
Hmm.
undervalued transaction.
Now basically it is the process of reversing the effect of that transaction. Yes.
Perfect. Yes.
The order under clause A of subsection 4 shall not be passed if it is proved by the bankrupt that the transaction was undertaken in the ordinary course of business of the
Hmm.
bankrupt, provided
Hmm.
that provisions of this subsection shall not be applicable to undervalued transaction entered into between a bankrupt and his associate under subsection 3 of this section.
So it says that even if it is an ordinary course of business, this plea will not work in case of a transaction with an associate. Right? Next.
For the purpose of this section, a bankrupt enters into an undervalued transaction with any person if
Hmm.
Any person.
Hmm.
if he has made a gift to that person, no consideration has been received by that person from the bankrupt, it is in consideration of marriage, or it is for a consideration the value of which in money or money's worth is significantly less than the value in money or money's
Hmm.
worth or
Money.
provided by the bankrupt.
So now, like in case of section 46, 46 says 2 years and 1 year, right? 2 years in case of related party and 1 year in case of unrelated party, right? But here, if a transaction is with a unrelated party, then is the period 1 year or 2 year only?
Sir, here the period is 2 years only is given.
हाँ, यहाँ पर कोई भी 1 year का पीरियड है ही नहीं. And 2 years also from the date of filing
Hmm.
of the application for bankruptcy. What is the meaning of it is in consideration of marriage? इसका क्या मतलब है? बाकी तो ठीक है, he makes a gift to that person, no consideration has been received by that person from the bankrupt. It is in consideration of marriage. क्या मतलब हुआ it is in consideration of marriage?
Means if he has given money for marriage, means from his account, and if it has triggered the bankruptcy of that person, then it will be considered.
हम्म. चलिए नेक्स्ट 165.
Preference transactions. The bankruptcy trustee may apply to the adjudicating authority for an order under this section if a bankrupt has given a preference to any person. The transaction given preference to an associate of the bankrupt under subsection should have been entered into by the bankrupt with the associate during the period of 2 years ending on the date of the application for bankruptcy, Any transaction giving preference not covered under subsection 2 should have been entered into by the bankrupt during the period of 6 months ending on the date of the application for bankruptcy.
तो यहां पर क्या हो गया, एसोसिएट के लिए 2 years हो गया और अदर देन एसोसिएट के लिए 1 year हो गया, 6 months, सॉरी 6 months हो गया है
Hmm.
ना? तो यहां पर क्या है, 6 months का भी पीरियड है। चलिए।
Any transaction giving preference not covered under subsection 2 should have been entered into by the bankrupt during the period of 6 months ending on the date of the application for bankruptcy. That the transaction giving preference under subsection 2 or under subsection 3 should have caused the bankruptcy process to be triggered. On the application of the bankruptcy trustee under subsection 1, the adjudicating authority may pass an order declaring a transaction giving preference void. Pass an order requiring any property transferred in respect of a transaction giving preference to be vested with the bankruptcy trustee as a part of the estate of the bankrupt, and pass any other order it thinks fit for restoring the position to what it would have been if the bankrupt had not entered into transaction giving preference.
राइट।
The adjudicating authority shall not pass an order under subsection 5 unless the bankrupt was influenced in his decision of giving preference to a person by desire to produce in relation to that person an effect under clause B of subsection 8. For the purpose of subsection 6, if the person is an associate of the bankrupt, otherwise than by reason only of being his employee at the time when the preference was given, it shall be presumed that the bankrupt was influenced in his decision under that subsection.
हाँ, तो इन केस ऑफ एसोसिएट इट इज ए डीमिंग फिक्शन।
For the purpose of this section, a bankrupt shall be deemed to have entered into a transaction giving preference to any person if the person is the creditor or surety or guarantor for any debt of the bankrupt, and the bankrupt does anything or suffers anything to be done which has the effect of putting that person into a position which in the event of the debtor become a bankrupt will be better than the position he would have been in if that thing had not been done.
So similar to section 53, here section 178 is there. So if the position is bettered because of this transaction, so then preference is deemed to have been given. Yes, next.
Order. Subject to the provision of subsection 2, an order passed by the adjudicating authority under section 164 or section 165 shall not give rise to a right against a person interested in the property which was acquired in an undervalued transaction or a transaction giving preference, whether or not he is the person with whom the bankrupt entered into such transaction, and require any person to pay a sum to the bankruptcy trustee in respect of the benefit received from the undervalued transaction or a transaction giving preference, whether or not he is the person with whom the bankrupt entered into such transaction. The provision of subsection 1 shall apply only if the interest was acquired or the benefit was received in good faith for value without notice that the bankrupt entered into the transaction at an undervalued or for giving preference, without notice that the bankrupt has filed an application for bankruptcy or a bankruptcy order has been passed, and by any person who at the time of acquiring the interest or receiving the benefit was not an associate of the bankrupt. Any sum required to be paid to the bankruptcy trustee under subsection 1 shall be included in the estate of the bankrupt.
So here, if the transferee gives this logic that the interest was acquired or the benefit was received in good faith for value and without notice of bankruptcy, so then this reversal will not be done, right? But in case of associate, even this plea will not work, right? So if an undervalued transaction or a preferential transaction has taken place with an associate, then he cannot give this logic that it was in good faith for value and without notice, right? This is the meaning. 167.
167. Extortionate credit transactions.
Hmm.
Subject to subsection 6, on an application by the bankruptcy trustee, the adjudicating authority may make an order under this section in respect of extortionate credit transactions to which the bankrupt is or has a party. The transactions under subsection 1 should have been entered into by the bankrupt during the period of 2 years ending on the bankruptcy commencement date.
अब देखो यहां थोड़ा सा डिफरेंस हो गया. यहां क्या हो गया? यहां बैंक्रप्सी कमेंसमेंट डेट आ गई. वहां पर क्या था? फाइलिंग. फाइलिंग ऑफ द एप्लीकेशन फॉर बैंक्रप्सी. जो अंडर वैल्यूड और प्रेफरेंशियल में है, वहां पर क्या है?
डेट ऑफ फाइलिंग ऑफ एप्लीकेशन ऑफ बैंक्रप्सी.
हाँ, और यहां पर आ गया आपका बैंक्रप्सी कमेंसमेंट डेट.
यस.
एक और बात ध्यान में रखनी है कि प्रेफरेंशियल ट्रांजेक्शन्स में 2 इयर्स और 6 मंथ्स का पीरियड
6 months. हाँ.
है ना, और अंडर वैल्यूड में 2 इयर्स का है ना. 1 ईयर तो नहीं है ना.
नहीं, यस सर.
हाँ, तो ये इतना सा ही ध्यान में रखना है. बाकी इतनी थ्योरी इसमें लिख रखी है, इसका कोई खास मतलब नहीं है. बाकी तो आपने 43 to 51 पढ़े ही है, वही सब रेपिटेशन ही है बेसिकली. जहां डिफरेंस है वो आपको नोट कर लेना है. द डिफरेंस इज इन द पीरियड एंड द लुक बैक पीरियड. यहां पर क्या है? 2 इयर्स एंडिंग ऑन द बैंक्रप्सी कमेंसमेंट डेट. और सेक्शन 51 में क्या है?
फिफ्टी
सेक्शन 51 में क्या है? एक्सटॉर्शनेट क्रेडिट ट्रांजेक्शन. वहां पर भी 2 इयर्स का ही है, 1 ईयर का पीरियड नहीं है ना. इन 51 ऑल्सो, 50 एंड 51, वहां पर भी 2 इयर्स का ही पीरियड है इन ऑल द केसेस. यहां पर भी 2 इयर्स का पीरियड है. वहां इंसॉल्वेंसी कमेंसमेंट डेट है और यहां पर बैंक्रप्सी कमेंसमेंट डेट है. यस प्लीज.
नहीं,
And on
हाँ बोलिए.
सर, पर उसमें उसकी इफेक्ट विल बी नलीफाइड. एक्सोर्नेट ट्रांजेक्शन होगा सर, तो इसकी इफेक्ट क्या आएगी सर?
नहीं,
इफेक्ट.
ट्रांजेक्शन में तो क्या है भाई? एडजुडिकेट अथॉरिटी में से दैट यू अल्टर द टर्म्स ऑफ द कॉन्ट्रैक्ट. भाई एक्सटॉर्शनेट क्रेडिट ट्रांजैक्शन है क्या बेसिकली? कि यू हैव एग्रीड टू समथिंग विच ए मैन ऑफ ऑर्डिनरी प्रूडेंस वुड नॉट हैव एग्रीड टू. ठीक है ना. आपने कुछ अनरीजनेबल टर्म्स एग्री कर लिए,
ओके सर.
तो
हाँ.
एडजुडिकेटिंग अथॉरिटी क्या बोलेगी? भाई उन टर्म्स को चेंज कर दो, है ना. ये बोलेगी.
हम्म.
हाँ,
हम्म.
ये है. चलिए.
ओके
an
सर.
order adjudicating authority में
हम्म. हाँ, ये आ गया ना जो आप पूछ रहे थे नरेंद्र जी.
हाँ हाँ
आपका
सर.
क्वेश्चन का आंसर आ गया
हाँ
कि
सर,
क्या
आंसर
करेगी
सर, यस.
एडजुडिकेटिंग अथॉरिटी. इट में
थोड़ा
सेट
पेशेंस
असाइड द
रखना है.
होल और पार्ट ऑफ एनी डेट
हाँ.
created by the transaction. It may vary the terms of the transaction or vary the terms on which any security for the purpose of transaction is held. Require any person who has been paid by the bankrupt under any transaction to pay a sum to the bankruptcy trustee. Require any person to surrender to the bankruptcy trustee any property of the bankrupt held as security for the purpose of this transaction. And any sum paid or property surrendered to the bankruptcy trustee shall be included in the estate of the bankrupt. ठीक है. और इसका क्या मतलब है? इसका मतलब यह है कि इट इज रिक्वायरिंग ऑन टर्म्स रिक्वायरिंग द बैंकरप्ट टू मेक एग्जॉर्बिटेंट पेमेंट्स इन रिस्पेक्ट ऑफ द क्रेडिट प्रोवाइडेड. भाई उसने कुछ उधार लिया. किसने? बैंकरप्ट ने. अब वो क्या कर रहा है? कोई ऐसी टर्म्स है जिसमें एग्जॉर्बिटेंट पेमेंट्स करनी पड़ रही है उसको. जैसे होता है ना, कई बार आप सब्जी वाले को उधार दे देते हो तो कहते हो भाई हम
जैसे.
10% पर मंथ का इंटरेस्ट लेंगे.
हाँ.
वैसा ही
यस
कुछ
सर, परफेक्ट.
है
यस.
ना.
8%
और
और 3% पर मंथ वाला ही
हाँ, और
कॉन्सेप्ट.
विच इज अनकॉन्शनेबल अंडर द प्रिंसिपल्स ऑफ लॉ रिलेटिंग टू कॉन्ट्रैक्ट्स. लेकिन इफ ए डेट हैज बीन एक्सटेंडेड बाय ए पर्सन रेगुलेटेड फॉर द प्रोविजन ऑफ फाइनेंशियल सर्विसेज, जैसे क्रेडिट कार्ड कंपनीज है. क्रेडिट कार्ड कंपनीज आर ऑल्सो चार्जिंग एग्जॉर्बिटेंट इंटरेस्ट, है ना.
हाँ.
36%, 39%, 42%. बट
हम्म.
वो जो है दैट शेल नॉट बी कंसिडर्ड टू बी ए एक्सटॉर्शनेट क्रेडिट ट्रांजेक्शन, क्योंकि आरबीआई से गवर्न है ना वो, इसलिए. यस. 168 पढ़िए मैडम. 168. हाँ.
yes, obligations under contracts.
हम्म.
This section shall apply where a contract has been entered into by the bankrupt with a person before the bankruptcy commencement date.
हम्म.
Any party to a contract other than the bankrupt under subsection 1 may apply to the adjudicating authority for an order discharging the obligations of the applicant or the bankrupt under the contract, and of damages by the party or the bankrupt for non-performance of the contract or otherwise. Any damages payable by the bankrupt by virtue of an order under clause B of subsection 2 shall be provable as bankruptcy debt when a bankrupt is a party to the contract under this section jointly with another person. That person may sue or be sued in respect of the contract without joinder of the bankrupt.
ये सेक्शन समझ में नहीं आया मैडम, कैन यू एक्सप्लेन दिस सेक्शन? क्या सेक्शन है ये? व्हाट इज दिस कॉन्सेप्ट ऑफ ऑब्लिगेशंस अंडर कॉन्ट्रैक्ट्स? क्या है ये?
सर अगर बैंक्रप्सी कमेंसमेंट डेट से पहले बैंक्रप्ट ने कोई कॉन्ट्रैक्ट किया हुआ है,
किस टाइप का कॉन्ट्रैक्ट?
एंटर्ड
कॉन्ट्रैक्ट तो
इनटू,
लिखा ही है, किस टाइप का कॉन्ट्रैक्ट होगा? कोई एग्जांपल दीजिए।
जैसे सेल परचेज गुड्स वगैरह होते हैं, सर्विसेज है, कोई भी कॉन्ट्रैक्ट सर्विस का हो या गुड्स का हो, अगर आपने वो कॉन्ट्रैक्ट किया हुआ है किसी पर्सन के कमेंसमेंट डेट से पहले, तो उसको एनफोर्स करवाने के लिए कि वो कॉन्ट्रैक्ट एनफोर्स हो जाए, वो जो पर्सन है वो एडजुडिकेटिंग अथॉरिटी को अप्लाई करता है। तो ऑर्डर फॉर डिस्चार्जिंग की वो बैंकरप्ट अपनी ऑब्लिगेशन डिस्चार्ज कर दे, और अगर वो कॉन्ट्रैक्ट फुलफिल नहीं कर रहा तो वो डैमेजेस पे करेगा। तो इसमें नॉर्मल कॉन्ट्रैक्ट ही आता है, चाहे सेल हो, परचेज हो, कैपिटल एसेट हो, कुछ भी हो। और अगर जॉइंट है, आप किसी के साथ जॉइंटली हो, तो वो उसके लिए अलग से दिया हुआ है, बैंकरप्ट इज अ पार्टी टू कॉन्ट्रैक्ट वेयर दिस सेक्शन इज जॉइंटली विद अनदर पर्सन, दैट पर्सन मे sue और बी sued in respect of the contract without joinder of the bankrupt।
काजल जी, कोई एग्जांपल दे सकते हैं इसके लिए आप? कोई एग्जांपल आपके माइंड में आ रहा है?
So right now
जैसे
नहीं
क्या
आ रहा।
होता है, कई बार ना हम कंस्ट्रक्शन कॉन्ट्रैक्ट्स करते हैं। अब मान लो जॉइंटली हम कोई एग्जीक्यूट कर रहे हैं कॉन्ट्रैक्ट, उसमें से एक आदमी बैंकरप्ट है, एक दूसरा है, ठीक है। अब क्या है कि अब ये बैंकरप्ट वाला जो बंदा है, इसकी सिचुएशन डिफरेंट है ना? तो वो ये कहता है कि भाई इस बंदे को छुटकारा दिलाओ। एनी पार्टी टू ए कॉन्ट्रैक्ट अदर देन द बैंकरप्ट मे अप्लाई टू द एडजुडिकेटिंग अथॉरिटी for an order discharging the obligations of the applicant or the bankrupt under the contract। मतलब ये है, होता क्या है कि मान लीजिए कंस्ट्रक्शन कॉन्ट्रैक्ट है। अब कंस्ट्रक्शन कॉन्ट्रैक्ट में लायबिलिटी आ जाएगी, क्योंकि एक आदमी इधर चला गया बैंक्रप्सी में, ये तो परफॉर्म कर नहीं पाएगा। अब दूसरा आदमी फंस गया, है ना? तो वो क्या कहता है कि भाई हमारा फैसला करवा दो इसमें, ठीक है। और अगर पेमेंट होनी है ऑफ डैमेजेस बाय द पार्टी और द बैंकरप्ट फॉर नॉन परफॉर्मेंस ऑफ द कॉन्ट्रैक्ट और अदरवाइज, मान लो उस कंस्ट्रक्शन कॉन्ट्रैक्ट में लिखा हुआ है कि भाई अगर आप कॉन्ट्रैक्ट परफॉर्म नहीं करोगे तो आपके ऊपर इतने डैमेजेस लगेंगे, है ना? तो इसके लिए किसके पास चले जाते हैं? बैंक्रप्सी, वो एडजुडिकेटिंग अथॉरिटी के पास, ठीक है। तो वो क्या करे, कौन अप्लाई करेगा यहां पर? अप्लाई कौन कर रहा है? जैसे मान लीजिए ए और बी, दे जॉइंटली एग्री टू एक्सिक्यूट ए सिविल कॉन्ट्रैक्ट, राइट? And there is a clause in the contract that if this contract is not performed, then they will be liable for damages of 50 lakhs। Now one of the party against one of the parties bankruptcy proceedings have started। Now the other party will be obliged to pay the entire thing। ये तो पहले ही भूखा नंगा है, बैंक्रप्सी प्रोसीडिंग इसकी स्टार्ट हो गई, इसका तो कुछ होना नहीं। दूसरी पार्टी फंस गई, दूसरी पार्टी की क्या करेगी? एडजुडिकेटिंग अथॉरिटी के पास जाएगी। तो कौन पार्टी जा रही है? एनी पार्टी टू ए कॉन्ट्रैक्ट अदर देन द बैंकरप्ट मे अप्लाई टू द एडजुडिकेटिंग अथॉरिटी। और वो कहेगी मिलॉर्ड, यू पास एन ऑर्डर डिस्चार्जिंग द ऑब्लिगेशंस ऑफ द एप्लीकेंट और द बैंकरप्ट अंडर द कॉन्ट्रैक्ट, कि हमारा जो भी ऑब्लिगेशंस है उसका, उसके बारे में एक ऑर्डर पास कर दो। और अगर कोई पार्टी ने डैमेजेस देने या बैंकरप्ट ने देने हैं फॉर परफॉर्मेंस ऑफ द कॉन्ट्रैक्ट और अदरवाइज, उसका भी फैसला आप कर दो, ये मतलब है।
But I have a question.
Okay, sir.
यस प्लीज।
But this contract, we cannot have a partial performance, no? See, contract means holistically it appears to be a fully performed or cannot be performed kind of thing,
No, no,
right?
no. Actually, here the adjudicating authority has the power. No, adjudicating authority here has the power because there were two parties to that civil contract, right? Now they entered into this contract before the bankruptcy commencement date. Now bankruptcy has started. So
Mhm.
now the rights and obligations of both the parties are different. Estate of the bankrupt has vested in the bankruptcy trustee, right? Now he cannot do anything. So the other party may be feeling now crippled because of bankruptcy of this person. So he will approach the adjudicating authority. Milord, you decide on this, the rights and obligations of both the parties. Who has to pay what?
Hmm.
Is there anything to be provided in the contract for this? Not required.
No, no, no. It is a provision of the law only. So law says like this.
Okay.
So it's,
Okay,
but
sir.
the only condition is this contract should have been entered into before the bankruptcy commencement date,
Hmm.
right?
Yes, sir.
So the only condition is that the date of entering into the contract should be before the bankruptcy commencement date and some other person also may be involved. So this section says how the obligations of the parties will be settled. This is the provision of this section basically.
Any
Yes.
damages payable, any damages payable by the bankrupt by virtue of an order under subclause B of subsection 2 shall be provable as bankruptcy debt.
So
And when
in this case, if the adjudicating authority decides that okay, this bankrupt also has to pay some damages, so they shall become a part of the bankruptcy debt.
when a bankrupt is a party to the contract under the section jointly with another person, that person may sue or be sued in respect of the contract without joinder of the bankrupt.
Hmm. Right. Next.
So, what is the meaning of without the joinder of the bankrupt? If
Now both have now A and B both have entered into the contract.
yes, sir.
Now against B, bankruptcy proceedings have started. So now he cannot be joined in that court case. Suppose there is a company XYZ Limited. XYZ Limited, they gave the contract to A and B. They were partners. Now B is into bankruptcy, right? So now B may not be sued. So A may be sued separately without joinder of the B, joinder of the bankrupt. So XYZ Limited will sue A only for non-performance and not B. This is the meaning. Now
Okay,
regarding
sir.
B, what will happen? Adjudicating authority will decide. If A has to pay anything, then it shall be provable as bankruptcy debt. ठीक है? इसके पास तो कुछ है ही नहीं बेचारे के पास, इसका तो सारा सामान बैंक्रप्सी ट्रस्टी के पास चला गया।
Hmm.
तो इसको अगर कुछ देना है तो कौन डिसाइड करेगा? एडजुडिकेटिंग अथॉरिटी। ठीक है,
Okay, okay, sir.
चलिए 169।
169 Continuance of proceedings on death of bankrupt. If a bankrupt dies, the bankruptcy proceedings shall continue as if he were alive.
तो अच्छा ये तो ठीक है, लेकिन इंसॉल्वेंसी में क्या होगा? सपोज इंसॉल्वेंसी प्रोसीडिंग्स हैव कमेंस्ड और इंसॉल्वेंट की डेथ हो गई, फिर क्या होगा? ये तो बैंक्रप्सी का तो ठीक है कि भाई अगर बैंक्रप्सी प्रोसीडिंग में डेथ हो जाए तो बैंक्रप्सी प्रोसीडिंग्स विल कंटिन्यू। इंसॉल्वेंसी में भी कुछ ऐसा है क्या?
सर डेथ के बारे में तो नहीं लिखा।
लीगल हायर सर।
नहीं, कहीं लिखा है क्या? बात तो वो है ना, लिखा है कि नहीं?
आई थिंक लीगल हायर। आई डोंट नो वेयर इट इज रिटन सर।
नहीं, थिंक से नहीं होता ना भाई, थिंक से
ओके
कुछ नहीं
सर।
होता। हाँ जी, इंसॉल्वेंसी में कुछ है क्या? भाई इंसॉल्वेंसी प्रोसीडिंग स्टार्ट हो गई और डेथ हो जाए इंसॉल्वेंट की तो क्या होगा? हो सकता है ना, डेथ तो हो ही सकती है।
So insolvency is a corporate, no? It's not a
No, no,
natural
no.
person.
Insolvency of an individual. We are talking of personal guarantor. A person has given a guarantee and now he has died during insolvency proceedings. So whether we can proceed against the legal representative, this is the question.
सर अगर आपके डेट्स फुलफिल नहीं होते तो उसमें रीपेमेंट प्लान में आ जाता है कि आपका कंप्लीट आपने नहीं किया उसको इनकम्प्लीट मान के उसमें बैंक्रप्सी ऑर्डर पास हो जाता है।
हम्म।
कुछ ऐसा तो पढ़ा ही था।
नहीं नहीं, वो तो ठीक है। मैं, मेरा क्वेश्चन तो डिफरेंट है ना। मेरा क्वेश्चन ये है कि इंसॉल्वेंसी प्रोसीडिंग्स हैव स्टार्टेड बट नाउ दैट अनडिस्चार्ज्ड इंसॉल्वेंट हैज डाइड, सो व्हाट विल हैपन?
और सर अगर लीगल हायर का अलग से नहीं भी दिया होता वो तो अंडरस्टूड ही होता है, अगर आपकी डेथ होती है तो लीगल हायर ऑटोमेटिकली आ जाते हैं।
हम्म।
वो तो जरूरी नहीं है कहीं दिया हो, वो तो अंडरस्टूड होता
तो
है।
यहाँ क्यों लिख दिया फिर? यहाँ भी अंडरस्टूड ही हो जाता।
सर यहाँ इसलिए लिख दिया कि जो आपने जब पेमेंट करनी है वाटरफॉल मैकेनिज्म से तो उसमें लीगल हायर की कहाँ पे स्टैंड करेंगे वो बताते हैं वो बाद में। उनकी जो लीगल हायर के अलावा जो उनका फ्यूनरल एक्सपेंसेस है वो सब उन्होंने सिक्योर डेट के बराबर माना है। इस वजह से शायद इसको अलग से दे दिया है। लेकिन लीगल हायर तो सर हमेशा ही आ जाते हैं किसी की डेथ होती है।
हम्म। चलिए नेक्स्ट।
Administ-
एडमिनिस्ट्रेशन ऑफ स्टेट ऑफ द डिसीज्ड बैंकरप्ट क्या कहता है? हाँ जी,
all
पढ़िए।
the provisions of Chapter 5
हम्म।
relating to
हम्म।
relating to the administration and distribution of the estate of the bankrupt shall, so far as the same are applicable, apply to the administration of the estate of a deceased bankrupt.
हम्म।
While administrating the estate of a deceased bankrupt, the bankruptcy trustee shall have regard to the claims by the legal representatives of the deceased bankrupt to payment of the proper funeral and testamentary expenses incurred by them.
ये टेस्टामेंट एक्सपेंसेस क्या होते हैं?
Testamentary.
तो जो डॉक्यूमेंट्स वगैरह जो फाइल
सर जो विल लिखते हैं ना कि
हम्म।
ये विल के लिए लॉयर हायर करते हैं कि मेरा विल लिख दो आप।
ठीक है, नेक्स्ट पढ़िए।
the claims under subsection 2 shall rank equally to the secured creditors in the priority provided under section 178.
हम्म।
If on the administration of the estate of a deceased bankrupt, any surplus remains in the hands of the bankruptcy trustee
अच्छा,
after
अगर मान
payment
लो
in
बैंकरप्ट की डेथ हो गई, ठीक है, अब उसके फैमिली मेंबर कह रहे हैं भाई हम तो इसको चंदन की लकड़ी में जलाएंगे, तो क्या अलाउड है? क्या होगा?
नो नो सर, जितना
क्या?
जेन्युइन है उतना मिलेगा उसको।
हाँ, क्या लिखता है? प्रॉपर फ्यूनरल एंड टेस्टामेंट्री एक्सपेंसेस, वर्ड प्रॉपर लिखा है उसने।
If on the administration of the estate of a deceased bankrupt, any surplus remains in the hands of the bankruptcy trustee after payment in full of all the debts due from the deceased bankrupt, together with the costs of the administration and interest as provided under section 178, such surplus shall be paid to the legal representatives of the estate of the deceased bankrupt or dealt with in such manner as may be prescribed.
यस, सेक्शन 171।
Section 171 Proof of Debts.
हम्म।
The bankruptcy trustee shall give notice to each of the creditors to submit proof of debt within 14 days of preparing the list of creditors under Section 132.
सो हियर द प्रोसेस इज ए बिट डिफरेंट। बैंक्रप्सी में क्या हो रहा है? पहले क्या कह रहा है? पहले कह रहा है यू रजिस्टर योर क्लेम्स, ठीक है। अब यहां क्या कह रहा है? यहां नोटिस दे रहा है टू सबमिट प्रूफ ऑफ डेट। पहले उसने लिस्ट प्रिपेयर कर ली, है ना। अब लिस्ट के बाद उनको कह रहा है कि भाई आप प्रूव करो डेट को। नहीं तो नॉर्मली क्या होता है कि जैसे आप क्लेम फाइल करो उसके साथ ही प्रूफ लगाना है। यहां
Hmm.
पहले क्या है? यहां पहले कह रहा है कि यू रजिस्टर योर क्लेम्स, और यहां हियर ही इज आस्किंग फॉर सबमिशन ऑफ प्रूफ ऑफ डेट।
Okay. The proof of debt shall require the creditor to give full particulars of debt, including the date on which the debt was contracted and the value at which that person assesses it.
इसका क्या
Required
मतलब हुआ? द वैल्यू एट विच द पर्सन असेसेस इट, व्हाट इज द मीनिंग?
सर इट मीन्स कि आज की डेट में आपका कितना बैलेंस आउटस्टैंडिंग है?
Right. So maybe that was contracted 5 years ago, and now you have to account for interest also. So this is the value as per as on this date, right?
Sir,
Requ-
what is the criteria for creating an interest? For
That
is there any
actually first
contract
of all you
or
have to see the terms of the contract. If
okay
terms
sir,
of
हाँ sir.
contract are not there, then you will take a reasonable rate.
मतलब ऐसा ही कि इनवॉइस में लिखा होना चाहिए कि इफ आफ्टर ड्यू डेट इट विल बी 18% लिवेबल
हाँ.
इंटरेस्ट. ओके
हम्म.
सर, ओके.
अगर नहीं लिखा है तो रिजनेबल देना पड़ेगा फिर.
नहीं
एट
सर, तो नहीं
परसेंट
देना
12%.
पड़ेगा सर.
जैसे सपोज इन केस ऑफ होम बायर्स इट इज गिवन कि वहां पर 8% दे रखा है इन केस ऑफ CIRP.
हाँ.
हम्म,
है ना. इफ नो रेट
ओके.
इज स्पेसिफाइड देन यू कैन टेक 8%. तो सिमिलर
हम्म.
कैलकुलेशंस कैन बी डन हियर आल्सो. यस.
ओके सर.
require the creditor to give full particulars of the security, including the date on which the security was given and the value at which that person assesses it.
हाँ, तो यहाँ पर भी सिक्योरिटी का भी जो है असेसमेंट होगा कि सपोज सिक्योरिटी में आपने प्रॉपर्टी मॉर्टगेज की हुई है. प्रॉपर्टी वाज मॉर्टगेज 10 years ago. आज की डेट में प्रॉपर्टी की वैल्यू कुछ अलग है. तो वो वैल्यू भी असेसमेंट आपको देनी है.
Be in such form and manner as may be prescribed.
हम्म.
In case the creditor is a decree holder against the bankrupt, a copy of the decree shall be a valid proof of debt.
हम्म.
Where a debt bears interest, that interest shall be provable as part of the debt, except in so far as it is owed in respect of any period after the bankruptcy commencement date.
हम्म.
The
क्या
bankruptcy
मतलब
trustee
क्या
shall
मतलब हो गया?
estimate.
व्हाट इज द मीनिंग?
So, where a debt bears interest, that interest shall be payable as part of the debt.
सर जो ये आपकी बैंक्रप्सी कमेंसमेंट डेट के बाद का इंटरेस्ट नहीं मिलेगा?
हम्म. 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 राइट.
The bankruptcy trustee shall estimate the value of any bankruptcy debt which does not have a specific value.
हम्म.
सर 3 वाला समझो. 171 3 वाला क्या है सर?
किसका?
171 3 उसमें सर
171(3) है ना. सपोज द क्रेडिटर इज होल्डिंग ए डिक्री, सो द कॉपी ऑफ द डिक्री शैल बी वैलिड प्रूफ ऑफ डेट. और कोई प्रूफ लगाने की जरूरत नहीं है. कॉपी ऑफ
ओके सर.
डिक्री लगा दो, वही डेट हो गया बस.
वो डिक्री क्या होता है सर? डिक्री, कॉपी ऑफ
भाई
डिक्री
डिक्री क्या
होल्डर.
होता है? सिविल कोर्ट में अगर आपको किसी से रिकवरी करनी है तो आप क्या करते हो? उसके अगेंस्ट में एप्लीकेशन फाइल करते हो.
ओके सर, हाँ
और
सर.
कोर्ट देखता है कि भाई यस रिकवरी इज ड्यू, तो वो क्या करता है? डिक्री इशू कर देता है. डिक्री इशू का मतलब इस बंदे की प्रॉपर्टी बेच करके उससे रिकवर करके इसको दूसरे बंदे को दे दो. दिस इज द मीनिंग ऑफ डिक्री.
ओके सर.
है ना.
Judgment.
अगर किसी कोर्ट ने डिक्री अवार्ड कर दी है, इसका मतलब वो एस्टेब्लिश हो चुका है ना डेट. अगर आप डेट की डेफिनेशन भी देखो तो डेट की डेफिनेशन में भी है ये बात कि इट इंक्लूड्स डिक्री होल्डर. है ना.
हाँ,
एक बार कौन सा सेक्शन है वो? सेक्शन 3 है, सेक्शन 5 है?
सर सेक्शन
सर सेक्शन 3 में ही कल डिस्कस कर रहे थे ना? सेक्शन 3 में 11, सब सेक्शन 11 या 12.
सेक्शन 10. सेक्शन 3 subsection 10. Creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, secured creditor, unsecured creditor and a decree holder. तो सेक्शन 3 subsection 10. यस प्लीज. चलिए.
a creditor may prove for a debt where payment would have become due at a date last later than the bankruptcy commencement date as if it were owed presently and may receive dividends in a manner as may be prescribed.
क्या मतलब है? व्हाट इज द मीनिंग? सपोज you have taken a car loan and that car loan is payable spread over a period of 5 years. Now the bankruptcy has started. So you will take the present value as if it were owed presently. ऐसा तो नहीं कह सकते ना भाई 5 साल की किस्तें हम तो 5 साल में ही देंगे. नहीं. बैंक्रप्सी हो गई तो आपको आज की डेट में उसका वैल्यू निकालनी है. दिस इज द मीनिंग.
Yes, sir. Where the bankruptcy trustee serves the notice under subsection 1 and the person on whom the notice is served does not file a proof of security within 30 days after the date of service of notice, the bankruptcy trustee may, with leave of the adjudicating authority, sell or dispose of any property that was subject to the security, free of that security.
So within 30 days he has to exercise that option. है ना? वहाँ liquidation में भी वही situation है. Yes, please. 172.
22 Proof of debt by secured creditors. Where a secured creditor realizes his security, he may produce proof of the balance due to him. Where a secured creditor surrenders his security to the bankruptcy trustee for the general benefit of the creditors, he may produce proof of his whole claim.
173 कोई ज्यादा इंपॉर्टेंट नहीं है. म्यूचुअल क्रेडिट सेंटर ऑफ, ठीक है, अलाउड होंगे. 174 है डिस्ट्रीब्यूशन ऑफ इंटरिम डिविडेंड. पढ़ लीजिए एक बार. 174.
174 Distribution of interim dividend.
हम्म.
Whenever the bankruptcy trustee has sufficient funds in his hand, he may declare and distribute interim dividend among the creditors in respect of the bankruptcy debts which they have respectively proved.
भाई देखो, प्रूव करते जाओ डेट और पैसे लेते जाओ. ठीक है ना? तो
Where,
इंटरिम डिविडेंड भी दे सकते हैं. यस.
where the bankruptcy trustee has declared any interim dividend, he shall give notice of such dividend and the manner in which it is proposed to be distributed.
अच्छा, ये
In the
नोटिस का क्या
calculation
मतलब है?
and
ये जो नोटिस है, ये कोई पेपर में देना है क्या? लिखा है नोटिस ऑफ सच डिविडेंड. तो नोटिस जो है आपको देना कहाँ है? पेपर में देना है क्या? कुछ रूल्स रेगुलेशंस में है, एक बार देखिए जरा. इसके रूल्स और रेगुलेशंस भी है ना. तो एक बार रूल्स या रेगुलेशंस में एक नजर मारिए कि कुछ है क्या ऐसा, कहता है क्या कुछ. पब्लिक नोटिस है कुछ क्या? हाँ जी, मिलता कुछ कहीं?
notes पर as such तो नहीं दिया हुआ.
चलिए कोई बात नहीं, देखते हैं, नजर आ जाएगा बाद में. चलिए प्लीज कंटिन्यू.
Where the bankruptcy trustee has declared any interim dividend, he shall give notice of such dividend and the manner in which it is proposed to be distributed. In the calculation and distribution of the interim dividend, the bankruptcy trustee shall make provisions for any bankruptcy debts which appear to him to be due to persons who, by reason of the distance of their place of residence, may not have had sufficient time to tender and establish their and any bankruptcy debts which are subject of claims which have not yet been determined, disputed proofs and claims, and expenses necessary for the administration of the estate of the bankrupt.
Hmm. Hmm. 175.
Distribution of property. The bankruptcy trustee may, with the approval of the committee of creditors, divide in its existing form amongst the creditors according to its estimated value any property in its existing form which from its peculiar nature or other special circumstances cannot be readily or advantageously sold.
Hmm.
An approval under subsection 1 shall be sought by the bankruptcy trustee for each transaction, and a person dealing with the bankruptcy trustee in good faith and for value shall not be required to enquire whether any approval required under subsection 1 has been given.
Hmm. क्या मतलब हुआ इसका?
So the bankruptcy trustee may, with the approval of the committee of creditors,
हम्म.
which is not sold,
हाँ.
then with the approval of the committee of creditors he can distribute that property as it is to the creditors
हम्म. हम्म.
circumstances.
इसका मतलब ये है कि अगर आपने प्रॉपर्टी डिस्ट्रीब्यूट कर दी अपने ड्यू अप्रूवल के साथ, तो कोई भी पर्सन जो गुड फेथ में एक्वायर करेगा उसको क्वेश्चन नहीं किया जा सकता।
हाँ, वो ये कहता है कि उसको उसका काम नहीं है देखना कि अप्रूवल लिया था या नहीं लिया था। भाई सीओसी से अप्रूवल, क्योंकि सीओसी के अप्रूवल के बिना आप नहीं कर सकते। लेकिन अगर किसी ने गुड फेथ और फॉर वैल्यू में एक्वायर किया है तो ही शैल नॉट बी रिक्वायर्ड टू इंक्वायर। उसका काम नहीं है पूछना कि आपने अप्रूवल लिया सीओसी से या नहीं। यस।
Where the bankruptcy trustee has done anything without the approval of the committee of creditors, the committee may, for the purposes of enabling him to meet his expenses out of the estate of the bankrupt, ratify the act of the bankruptcy trustee. The
हम्म.
committee of the creditors shall not ratify the act of the bankruptcy trustee under subsection 3 unless it is satisfied that the bankruptcy trustee acted in a case of urgency and has sought its ratification without undue delay.
राइट. 176.
176 Final dividend. Where the bankruptcy trustee has realized the entire estate of the bankrupt or so much of it as could be realized in the opinion of the bankruptcy trustee, he shall give notice of his intention to declare a final dividend or that no dividend or further dividend shall be declared. The notice under subsection 1 shall contain such particulars as may be prescribed and shall require all claim against the estate of the bankrupt to be established by a final date established in the notice.
अभी ये
The
इसके लिए यहाँ पर रूल 13 है। तो ये रूल 13 क्या कहता है? ये रूल 13 कहता है, ये रूल 13 है। रूल 13 भी पढ़ लीजिए एक बारी।
notice of dividend. The
हम्म.
notice of dividend as per clause A of subsection 1 of section 176 shall contain the following particulars:
हम्म.
the date on which the dividend is proposed to be distributed, the
हम्म.
list of creditors who shall be entitled to a dividend,
हम्म.
the amount of dividend for each creditor under clause B,
हम्म.
request for any details required from the creditors for the distribution of dividend, and the last date for receipt of such information.
हम्म.
The last date by which the creditors must establish their claim against the estate with the bankruptcy trustee, and if a statement confirming that no further dividend shall be declared.
हम्म.
The notice under clause B of subsection 1 of section 176 shall provide the reasons for not declaring dividend. The notice of dividend under subsection 1 section 176 shall be sent 30 days prior to the date specified for the distribution of dividend.
हम्म. ये कहाँ गया? ये लास्ट वीट पे आ गया। ठीक है जी, यहाँ पर थे ना हम लोग। चलिए 176, तो लास्ट वीट से दोबारा वहीं पहुंच गए। चलिए नेक्स्ट 3 पढ़िए। 176 3.
The adjudicating authority may, on the application of any person interested in the administration of the estate of the bankrupt, postpone the final date referred to in subsection 2.
Hmm.
After final date referred to in subsection 2, the bankruptcy trustee shall defray any outstanding expenses of the bankruptcy out of the estate of the bankrupt,
Hmm.
and if he intends to declare a final dividend, declare and distribute that dividend among the creditors who have proved their debts without regard to the claims of any other persons.
Hmm.
If a surplus remains after payment in full with interest to all the creditors of the bankrupt and the payment of the expenses of the bankruptcy, the
Hmm.
bankrupt shall be entitled to the surplus.
Hmm. Yes.
Where a
Hmm.
bankruptcy order has been passed in respect of one partner in a firm, a creditor to whom the bankrupt is indebted jointly with the other persons in the firm or any of them shall not receive any dividend out of the separate property of the bankrupt until all the separate creditors have received the full amount of their respective debts.
Hmm. मतलब क्या है इसका? मतलब भी तो कुछ होगा इसका. इसका मतलब ये है बिकॉज डिविडेंड इज बीइंग डिस्ट्रीब्यूटेड इन ट्रेंचेस, राइट? सो सपोज द फर्स्ट ट्रेंच हैज बीन सर्व्ड, राइट? But now second trench is being given. So before giving second helping, एक बारात में बाराती बैठे हुए हैं, ठीक है? सबको एक एक लड्डू दे दिया. एक आदमी आया ही नहीं था तब तक. अब जब वो आ गया तो दूसरे को दूसरा लड्डू देने से पहले उसको पहला लड्डू दिया जाएगा. दिस इज द मीनिंग. ठीक है
Yes,
नरेंद्र
yes.
जी?
ओके सर, सही
हाँ,
है सर.
चलिए.
Section 177 Claims of Creditors. A
हम्म.
creditor who has not proved his debt before the declaration of any dividend is not entitled to disturb by reason that he has not participated in it, the distribution of that dividend or any other dividend declared before his debt was proved.
हम्म.
But when he has proved the debt, he shall be entitled to be paid any dividend or dividends which he has failed to receive out of any money for the time being available for the payment of any further dividend,
हाँ.
and any dividends payable to him shall be paid before that money is apply, applied to the payment of any such further dividend.
हाँ, तो ये लड्डू वाला एग्जांपल 177 के लिए. हाँ जी.
No action shall lie against the bankruptcy trustee for a dividend, but if the bankruptcy trustee refuses to pay a dividend payable under subsection 1, the adjudicating authority may order him to pay the dividend and pay out of his own money interest on the dividend and the cost of the proceedings in which the order to pay has been made.
हम्म. ठीक है. अब मान लीजिए अगर वो इस हिसाब से नहीं देता जो 177(1) में लिखा है. 177(1) में क्या लिखा है? वो लिखता है कि भाई ठीक है, एक आदमी, वन पर्सन कुड नॉट प्रूव इज डेट. नाउ ही हैज कम एट अ लेटर डेट. सो in the second helping, you first of all give to him whatever has been given to the other persons who have proved their debt. And if he doesn't do so, then he might be made personally responsible. कि भाई आप अपने जेब से दो इंटरेस्ट एंड द कॉस्ट ऑफ द प्रोसीडिंग. यस. 178.
178 Priority of payment of debts.
हम्म.
Notwithstanding anything to the contrary contained in any law enacted by the Parliament or the state legislature for the time being in force, in the distribution of the final dividend, the following debts shall be paid in priority to all other debts.
हम्म.
First, the costs and expenses incurred by the bankruptcy trustee for the bankruptcy process in full.
हम्म.
Secondly, the workman's dues for the period of 24 months preceding the bankruptcy commencement date
हम्म.
and debts owed to secured creditors.
हम्म.
Thirdly, wages and any unpaid dues owed to employees other than workmen of the bankrupt for the period of 12 months preceding the bankruptcy commencement date.
हम्म. Fourthly.
Fourthly,
हम्म.
any amount due to the central government and the state government, including the amount to be received on account of Consolidated Fund of India and the Consolidated Fund of a state, if any, in respect of the whole or any part of the period of 2 years preceding the bankruptcy commencement date. Lastly, all other debts and dues owed by the bankrupt, including unsecured debts. The debts in each class specified in subsection 1 shall rank in the order mentioned in that subsection, but debts of the same class shall rank equally amongst themselves and shall be paid in full unless the estate of the bankrupt is insufficient to meet them, in which case they shall abate in equal proportion between themselves. Where creditor has given any indemnity or has made any payment of monies by virtue of which any asset of the bankrupt has been recovered, protected, or preserved, the adjudicating authority may make such order as it thinks fit, as it thinks just with respect to the distribution of such asset, with a view to giving that creditor an advantage over other creditors in consideration of the risk taken by him in so doing.
So it says, suppose somebody has helped in recovery of some money, right? So in that case, the adjudicating authority may make an order if that asset is being distributed, right? With a view to giving that creditor an advantage over other creditors in consideration of the risk taken by him in so doing. Like we give the example of a property which was recovered due to the efforts of this particular person. So if that property is being distributed, so this person may be given advantage who has helped in recovery of that property. This is the meaning.
Unsecured creditors shall rank equally amongst themselves unless contractually agreed to the contrary by such creditors. Any surplus remaining after the payment of the debts under subsection 1 shall be applied in paying interest on those debts in respect of the periods during which they have been outstanding since the bankruptcy commencement date.
अब यहां देखिए ये फिफ्थ पॉइंट क्या बोलता है कि सपोज डेट्स हैव बीन पेड, अभी भी कुछ सरप्लस बच गया, उसमें जो इंटरेस्ट है इन रिस्पेक्ट ऑफ द पीरियड ड्यूरिंग विच दे हैव बीन आउटस्टैंडिंग सिंस द बैंक्रप्सी कमेंसमेंट डेट, बैंक्रप्सी कमेंसमेंट डेट के बाद भी कुछ इंटरेस्ट है तो वो दे दिया जाएगा। पहले तो बैंक्रप्सी कमेंसमेंट डेट तक का इंटरेस्ट कैलकुलेट होगा, उसके बाद मान लीजिए सबको पेमेंट हो गया, still there is some surplus, so then that surplus shall be applied. But इसमें पॉइंट नंबर 6 क्या बोलता है, इंटरेस्ट पेमेंट्स अंडर सबसेक्शन 5 shall rank equally irrespective of the nature of the debt. तो इंटरेस्ट पेमेंट्स में आपको नेचर नहीं देखना है, फिर इंटरेस्ट पेमेंट ये नहीं देखना है सिक्योर्ड है अनसिक्योर्ड है वेजेस है एम्प्लॉयज है, सबको बराबर बराबर दे देना है, ये मतलब है।
In the case of partners, the partnership property shall be applicable in the first instance in payment of the partnership debts, and the separate property of each partner shall be applicable in the first instance in payment of his separate debts.
क्या मतलब है इसका? इसका मतलब ये है कि हियर वी आर डीलिंग विद partners. They may be having their individual property also, and there may be a property of the partnership firm also. So in this case, suppose partnership debt is due. So partnership debt shall first be paid out of the property of the partnership firm and then out of the separate property. Similarly, if an individual debt is due, suppose a partner has taken loan in his personal capacity. So first of all, his personal property will be utilized for the payment of that debt, and still if something is due, then the partnership property shall be utilized, because the liability of the partners is joint and several. Right.
Where there is surplus of the separate property of the partners, it shall be dealt with as part of the partnership property, and where there is a surplus of the partnership property, it shall be dealt with as part of the respective separate property in proportion of the rights and interests of each partner in the partnership property.
So I have given an example also for this, how it is to be used. आज इतना ही कर लेते हैं मेरे ख्याल, है ना?
Okay, sir.
है ना? या ये 2-3 सेक्शन पढ़ने तो पढ़ लो फटाफट, कोई ज्यादा लंबा नहीं है वैसे इसमें, अगर इसको पढ़ना है तो 2-4 ही सेक्शन है। सेक्शन
Yes, sir.
179, नाउ व्हाट सेक्शन 179 से, सेक्शन 179 दे आर
Hmm.
मेकिंग इट सब्जेक्ट टू सेक्शन 60.
160. Hmm.
So it says subject to the provisions of section 60. Now please understand that the rules and regulations relating to individuals and partnership firms have not yet been notified. ठीक है? Rules and regulations have been notified only in respect of personal guarantors to corporate debtors.
Body.
ठीक है? So far as personal guarantors to corporate debtors are concerned, their
Adjudicating authority will be NCLT
adjudicating
and not
authority shall
DRT.
be NCLT,
And
having
not DRT.
territorial jurisdiction over the registered office of the corporate person.
Perfect, sir.
But suppose tomorrow these rules and regulations are notified for individuals and partnership firms also, and a person has taken a loan in his individual capacity. So in that case, the adjudicating authority shall be the DRT. This is the meaning. Okay. 180 says civil courts not to have jurisdiction. 181 says appeal to DRT within 30 days and then another 30 days. Okay. So the appeal can be filed within further period not exceeding 15 days. So 30 plus 15 and appeal to Supreme Court 45 plus 15 in case of justifiable reasons. And 183 says that even the debt recovery tribunal or DRAT, they shall record reasons in case there is a delay by them. ठीक है? And there is a special power to the chairperson of the DRAT after taking into account the reasons so recorded, extend the period specified in this code but not exceeding 10 days. So there is a special power which is given to the chairperson of the DRAT. बट क्या डीआरटी को भी पावर है? यहां पर बोल रहा है कि डीआरएटी को पावर है टू एक्सटेंड द पीरियड नॉट एक्सीडिंग 10 डेज। बट माय क्वेश्चन इज डीआरटी को भी पावर है क्या? अब इस सेक्शन के अगेंस्ट में आप एक दूसरा सेक्शन में आपको बताता हूं, वो सेक्शन है आपका सिमिलर सेक्शन है 64। 64 क्या बोलता है? 64 बोलता है प्रेसिडेंट ऑफ एनसीएलटी एंड चेयरपर्सन ऑफ एनक्लैट दे हैव द पावर टू एक्सटेंड नॉट एक्सीडिंग 10 डेज। वहां पर दोनों को पावर है, प्रेसिडेंट ऑफ एनसीएलटी एंड चेयरपर्सन ऑफ एनक्लैट। लेकिन यहां पर डीआरटी को पावर नहीं दे रखी, ऐसा लग रहा है देखने से। नहीं, यहां पावर किसके पास है? चेयरपर्सन ऑफ डीआरएटी। और अगर 64 पढ़ते हो आप, सेक्शन 64, तो वहां दोनों के पास पावर है, प्रेसिडेंट ऑफ एनसीएलटी के पास और चेयरपर्सन ऑफ एनसीएलटी, दोनों में फर्क है ना? क्वेश्चन सेट कर सकता है छोटी छोटी बातों पे। चलिए जी, आज का सत्संग यहीं समाप्त करते हैं।
ओके सर, नमस्ते सर।
नमस्ते।
Yes, sir.
गुड नाइट सर।
ओके जी, गुड नाइट।
गुड नाइट। गुड नाइट सर।